Welcome back to SCOTUS Oral Arguments and Opinions. This is the last of 4 episodes from today. In this episode, we'll discuss the June 26th, 2025 Supreme Court opinion in the case called Riley v. Bondi, case number 23-1270. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 5-4 that immigrants must file their appeals within 30 days of when the government initially orders their removal, not within 30 days of when immigration judges later decide their protection claims. The Supreme Court ruled 9-0 that the 30-day filing deadline is not jurisdictional. The case centered on Pierre Riley, a Jamaican citizen who sought protection from torture but filed his court appeal in 2022 after losing before the Board of Immigration Appeals, rather than in 2021 when the government first ordered his deportation. Justice Alito's majority opinion held that removal orders become final immediately upon issuance, even when separate protection proceedings are still pending, but all 9 justices unanimously agreed that the 30-day filing deadline is not a jurisdictional requirement that courts must enforce on their own. The decision means that immigrants like Riley, who don't contest their removability but seek protection from torture or persecution, must file protective appeals before they even know if they'll win their protection claims. In this episode, we'll compare the interpretation in Justice Alito's majority opinion against Justice Sotomayor's dissent, which argued the court created an incoherent system requiring appeals before orders exist while exploring the rare unanimous agreement on jurisdictional rules. Then we'll analyze the judicial dynamics where all 9 justices joined the non-jurisdictional holding, while Justice Thomas raised entirely separate concerns about whether courts can review these cases at all. Finally, we'll consider the practical implications for immigration law and why even the government supported the losing side. The questions presented in this case are: 1. Whether 8 U.S.C. 1252 B1's 30-day deadline is jurisdictional or merely a mandatory claims processing rule that can be waived or forfeited. 2. Whether a person can obtain review of the BIA's decision in a withholding-only proceeding by filing a petition within 30 days of that BIA decision. Justice Alito delivered the opinion of the court in which Chief Justice Roberts and Justices Thomas, Kavanaugh, and Barrett joined in full, and in which Justices Sotomayor, Kagan, Gorsuch, and Jackson joined only as to Part 2, which is Justice Thomas filed a concurring opinion. Justice Sotomayor filed an opinion dissenting in part, in which Justices Kagan and Jackson joined in full, and in which Justice Gorsuch joined except as to Part 4.
Justice Alito's majority opinion. The Department of Homeland Security, DHS, sought to remove Pierre Riley, a citizen of Jamaica, from the United States under expedited procedures for aliens convicted of aggravated felonies. On January 26, 2021, the DHS issued a final administrative review order, FARO, directing Riley's removal to Jamaica. Under 8 U.S.C. Section 1228B3, aliens may petition courts of appeals for FARO review. While Riley did not contest his removal from the United States, he sought relief under the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, CAT, telling an immigration officer that he would likely be killed by a drug kingpin if he returned to Jamaica. The officer concluded that Riley did not demonstrate reasonable fear of persecution, but an immigration judge, I.J., disagreed and concluded that Riley was entitled to relief under the CAT, which prohibits removal to countries where torture is likely. The I.J. sent Riley's case to a withholding-only proceeding to determine whether he could be removed to Jamaica. At that proceeding, the I.J. found Riley credible and granted deferral of removal to Jamaica under the CAT. The DHS appealed to the Board of Immigration Appeals, BIA, which vacated the IJ's order and allowed the FARO's enforcement. 3 days later, Riley filed a petition for review in the Fourth Circuit. The Fourth Circuit dismissed Riley's petition for lack of jurisdiction, holding that 1. Aliens cannot obtain review of BIA decisions in withholding-only proceedings by filing within 30 days of that decision, and 2. Section 1252, B1's 30-day filing deadline is jurisdictional, not merely a mandatory claims processing rule. Held, 1 BIA orders denying deferral of removal in withholding-only proceedings are not final orders of removal under Section 1252B1. An order of removal includes an order of deportation, which in turn is defined as an order concluding that the alien is deportable or ordering deportation. The FARO issued by DHS on January 26, 2021 is the final order of removal under the statute because it held that Riley was deportable and directed that he be removed from the United States. The order was also the executive's final determination on the question of removal. An order of removal becomes final at the earlier of 2 points. 1. A determination by the BIA affirming such order, or 2. The expiration of the period in which the alien is permitted to petition the BIA for review of the order. Because an alien in streamlined removal proceedings cannot seek review of his FARO before an IJ or the BIA, the period to seek review expires as soon as the FARO is issued, meaning that the order becomes final immediately upon issuance. The court's decisions in Nasrallah versus Barr and Johnson versus Guzman Chavez buttress this conclusion. In Nasrallah, the court noted that CAT orders are not final removal orders because they do not conclude that an alien is deportable or order deportation. The court held that CAT orders do not disturb or affect the validity of final removal orders, so they do not merge into final orders because only rulings affecting the validity of a final removal order will merge into the final order for purposes of judicial review. Guzman Chavez addressed whether aliens could be released during the pendency of their withholding-only proceedings. The court held that the directive that they be removed had become administratively final, regardless of their pending CAT proceedings, and the finality of an order of removal does not depend in any way on the outcome of the withholding-only proceedings. The government argues that the question in Guzman Chavez was whether the removal order in that case was administratively final for purposes of detention, not whether a removal order constitutes the final order of removal for purposes of filing. But this argument conflates when a petition for review must be filed with the issues that may be adjudicated in that proceeding. The government then compares the purposes of finality in Section 1252B1 and 1231, arguing that the meaning differs. Although finality may serve different purposes under different statutes, it does not follow that the meaning of finality necessarily varies. The government raises legitimate practical concerns about removal orders becoming final before withholding-only relief is decided, but the court must follow statutory text and precedent. The text and precedents make clear that the FARO is the final order of removal, and withholding-only proceedings do not disturb the finality of otherwise final removal orders. 2. The 30-day filing deadline under Section 1252B1 is a claims processing rule, not a jurisdictional requirement. Categorizing a rule as jurisdictional has important consequences that may disrupt the orderly and efficient adjudication of cases in the federal courts. Court precedent shows reluctance to label rules jurisdictional, unless Congress clearly signals that intent. While Congress need not use magic words to indicate that a rule is jurisdictional, Henderson versus Shinseki, 562 U.S. 428436, the court's recent decisions require an exceedingly strong signal for jurisdictional classification. That demanding requirement is not met here. Section 1252 B1 states petitions must be filed not later than 30 days after the date of the final order of removal. This language tells aliens what to do to obtain judicial review, but it provides no directives to courts. It does not reference jurisdiction and lacks any language demarcating a court's power. Harrow versus Department of Defense, 601, U.S. 480484. The placement of the statute also suggests it is not jurisdictional because neither the particular subsection nor the broader section in which the deadline is placed concerns jurisdiction. Precedents extending back nearly 20 years support classifying Section 1252 B1's deadline as a claims processing rule. Before Arbaugh v. Y&H Corporation, the court occasionally classified non-extendable time limits as jurisdictional. In Arbaugh, however, the court made clear that courts should only treat statutory limitations as jurisdictional if Congress clearly states that they have jurisdictional consequences. The court's cases since Arbaugh have almost uniformly found that the provisions at issue fail this demanding test. The one exception is John R. Sand and Gravel Company versus United States, where the court would not overturn a definitive earlier interpretation of a statute as jurisdictional without clear congressional directive. There, century-old decisions held that the provision was truly jurisdictional. While Stone v. INS characterized Section 1252b1's predecessor provision as jurisdictional, it used the term loosely and did not attend to the distinction between jurisdictional rules, as we understand them today, and non-jurisdictional but mandatory ones. Since Stone, the court has repeatedly found that filing deadlines, including mandatory ones, are not jurisdictional. Section 1252's 30-day filing rule is not jurisdictional, but because the government does not wish to press that ground for dismissal, the court's holding does not preclude this case from proceeding on remand. Vacated and remanded.
Justice Thomas's concurring opinion. I agree and join the court's opinion in full. I write separately to note that the Fourth Circuit may nevertheless lack jurisdiction over this suit for a different reason. Petitioner Pierre Riley sought review of an order of the Board of Immigration Appeals, entered on May 31, 2022. The court today holds that this May 31st order is not a final order of removal. Instead, it is an order denying relief under the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, CAT. Congress has specified that federal courts of appeals lack jurisdiction to review CAT orders, except as part of the review of a final order of removal. Thus, on remand, the Fourth Circuit should consider whether it has jurisdiction to review a CAT order when the court is not conducting that review as part of the review of a final order of removal. Through a series of statutory enactments, Congress has established a comprehensive framework for judicial review of a final order of removal. A final order of removal is a final order concluding that the alien is deportable or ordering deportation. The Illegal Immigration Reform and Immigrant Responsibility Act of 1996, IREI, grants the federal courts of appeals jurisdiction to review an alien's final order of removal. The statute makes the filing of a petition for review in accordance with the procedures outlined in IRERA the sole and exclusive means for an alien to obtain judicial review of such an order. This court has made clear that CAT orders are not the same as final orders of removal. While IRERA acknowledges that an alien may bring a claim under the CAT, jurisdiction for judicial review of CAT claims comes from a different statute, the Foreign Affairs Reform and Restructuring Act of 1998, FARA. FARA specifies that no federal court shall have jurisdiction to consider or review claims raised under the CAT except as part of the review of a final order of removal pursuant to 8 U.S.C. Section 1252. I do not see how the Fourth Circuit has jurisdiction to review a CAT order in isolation when petitioner does not seek review of a final order of removal. Congress has provided that federal courts of appeals lack jurisdiction to review an order denying CAT relief except as part of the review of a final order of removal. Riley has undoubtedly received a final order of removal, but he has never sought judicial review of that order pursuant to the procedures outlined in Section 1252. This court has held that CAT orders may be reviewed together with final orders of removal in a court of appeals. But as far as I am aware, we have never held that judicial review of CAT orders is available when an alien does not petition for review of a final order of removal. On remand, the Fourth Circuit must assure itself of its jurisdiction before it can proceed to the merits of Riley's petition. I encourage the Fourth Circuit to consider whether it has jurisdiction to review a CAT order, and only a CAT order, when petitioner does not seek review of a final order of removal.
Justice Sotomayor's opinion. Dissenting in part, the majority correctly holds that the deadlines in this case are not jurisdictional. So I join Part 2B of its opinion. I dissent from the remainder of the majority opinion. Sometimes to ask a question, is to answer it. When Petitioner Pierre Riley received an order from the Department of Homeland Security notifying him it would seek to deport him to Jamaica, he timely sought deferral of that removal on the ground that he would likely be killed upon his return there. After initially winning such relief from an immigration judge, Riley lost before the Board of Immigration Appeals. The question is, when Riley should have petitioned for judicial review of the board's order, was his petition due 30 days after the government first notified him he would be deported, well over a year before the board issued the order Riley sought to challenge? Or was it instead due 30 days after the order denying his claim for deferral of removal? The answer is clear. One should not be required to appeal an order before it exists. Incomprehensibly, the court disagrees. It acknowledges that the immigration laws required Riley to appeal the department's decision that he was deportable, together with the board's much later order denying him relief from removal to Jamaica. It admits that the only way to review both orders is to do so after the latter of the two issues. Yet it concludes Riley's appeal was due before the board issued the second order, because Congress did not write so incoherent a judicial review provision. I respectfully dissent. Should Riley have appealed the board's order denying deferral of removal before the board issued it? The answer ought to be easy. Yet the majority today renders the statute incoherent, holding that Riley should have appealed the order 1 year and 3 months before the board entered it. According to the majority, statutory text and our prior precedents require this absurd result. Our nation's immigration laws may be complex, but the irrational scheme the court endorses today is a product entirely of its own creation. Statutory text and precedent overwhelmingly confirm what common sense tells us. Riley's appeal was timely. Although the majority purports to be bound by the statute, its cursory analysis elides all but one of the relevant provisions. Background on the statutory scheme is accordingly necessary to understanding why the question in this case arises. Riley's order of removal did not become final for purposes of appeal until the board issued its order denying CAT relief. Congress expressly provided for judicial review of any cause or claim under CAT. Self-evidently, such review cannot take place until the board has denied relief. Meanwhile, Congress directed that CAT orders must be appealed alongside the underlying order of removal. The only way to adhere to both instructions is to hold that removal orders do not become final until withholding-only proceedings are complete. Centuries of precedent on finality confirm that conclusion. The majority claims the statutory definition renders the order of removal final immediately upon its issuance. That is so, the majority says, because when a removal order is not appealable, the period to seek review of it expires as soon as the order is issued. In other words, the majority treats a non-existent appeals period as if it were merely an infinitesimally short period, one so short as to expire instantaneously. That makes no sense. Expiration, after all, means the conclusion or termination of a limited time. A period of time cannot expire if it never begins in the first place. An order becomes final when it leaves nothing to be looked for or expected, when it leaves no further chance for action, discussion, or change. Of course, an order can be terminal in one sense and not another. This multiplicity of finality rules makes clear that it is not enough to muse about finality in the abstract. Rather, the court must focus on the specific sense of finality relevant here, which all agree is finality for purposes of appeal. As a general matter, an order is final for purposes of appeal when the district court disassociates itself from the case, leaving nothing to be done at the court of first instance save execution of the judgment. That understanding of finality serves one central purpose: preventing piecemeal litigation. The reason for that focus is simple. The only way to ensure that orders are appealed together is to have them become final together as well. The majority, nonetheless, adopts the opposite position, contrary to every one of this court's finality precedents. Yet statutory text and this court's precedent are crystal clear on this point. Congress provided for judicial review of CAT claims. Section 1252 of 4 provides that a petition for review under that section shall be the sole and exclusive means for judicial review of any cause or claim under the CAT. No exclusive means for review would be possible if review were unavailable. Besides its half-hearted attempt to invoke the inapplicable statutory definition, the majority offers a single thought about the dispositive issue of finality. The original order, it says, was dot. The executive's final determination on the question of removal, so it constituted the final order of removal in this case. The implication is that because this order was a final determination, it became final the moment it was issued. This argument conflates two different questions: when the agency made its final decision on the question of removability, and when the order of removal became final for appellate purposes. The majority's skewed reasoning betrays a fundamental misunderstanding of the final judgment principle. Every interlocutory order finally determines the limited question it decides, but of course, that does not mean every order becomes instantly final for purposes of appeal. In failing to recognize as much, the majority breaks with basic principles of finality and appellate review, holding, seemingly for the first time, that two orders that statutorily must be appealed together nonetheless do not become final together. The court overlooks Santos Zacaria, Monsalvo Velasquez, and the wealth of precedent on finality, claiming instead that two other cases are instructive and require a different outcome here. Neither case supports the majority's conclusion. Today's holding deals untold damage to basic principles of finality and judicial review. Time will tell whether the court will extend its illogic beyond politically disfavored non-citizens. As it stands, the chaos the majority causes to our system of immigration appeals is considerable. Finally, lest one think today's decision will at least allow the government to conduct its immigration policies more cheaply or efficiently, even that is not the case. It is not by accident that the government, across the past and present administration, stands firmly with Riley here, even as it rarely fails to press colorable jurisdictional objections. As the government knows, a whole train of unnecessary consequences follows from requiring non-citizens to appeal in every expedited removal case simply to protect their eventual right to appeal future withholding-only decisions. In each of these unnecessary appeals, the board and other parties may be called upon to respond and oppose the motion for review. When the board acts, the petition for review, dissenting in part, must be amended to bring the petition up to date, or dismissed if the board grants the non-citizen's CAT claim. All the while, courts must manage countless cases that otherwise might never have been opened. The government recognizes all these consequences. This court is blind to them. Today's decision is the rare holding that benefits no one. Not long ago, this court described delays in regulatory approvals of construction projects as bordering on the Kafkaesque. In holding that Riley was required to file his appeal 16 months before the order he sought to challenge existed, the court surely moves from the border well into the heartland of illogic and absurdity. Respectfully, I dissent.
Those were the majority, concurring, and dissenting opinions. Now let's talk about the one area where all 9 justices found common ground. Part 2. B of Justice Alito's majority opinion dealing with whether filing deadlines are jurisdictional. This is actually a big deal because it represents unanimous agreement on the court. Chief Justice Roberts and Justices Thomas, Kavanaugh, and Barrett joined the entire majority opinion, while Justices Sotomayor, Kagan, Gorsuch, and Jackson specifically joined only this Part is got B section. So we have all 9 justices agreeing on this point. The court held that the 30-day filing deadline under Section 1252 B1 is what's called a claims processing rule, not a jurisdictional requirement. Why does this matter? Well, jurisdictional rules are different. Courts must raise jurisdictional issues on their own, even if parties don't bring them up. But claims processing rules can be waived if the government doesn't assert them. Justice Alito wrote that categorizing a rule as jurisdictional may disrupt the orderly and efficient adjudication of cases in the federal courts. The court has been reluctant to label rules jurisdictional unless Congress clearly signals that intent. Here, the statute just tells aliens what they must do to get judicial review. It doesn't give any directives to courts about their power. The fight in this case was about when someone must file their appeal. The majority held that Riley had to file his appeal right after the government said, "We're going to deport you in January 2021, even though the judge didn't decide until May 2022 whether Riley could stay. The dissent said that's crazy because a person can't appeal a decision before the judge makes it. It's like having to complain about your report card before your teacher has even graded your test. Justice Sotomayor said this will create confusion about whether people must file appeals for things that haven't happened yet. Justice Gorsuch sided with Justice Sotomayor in the dissent regarding the question about when someone must file their appeal. But here's where Justice Gorsuch drew the line. While he joined the other liberal justices in agreeing that filing deadlines aren't jurisdictional, he refused to join Part 4 of Justice Sotomayor's dissent. That's the section where she really unloaded on the majority's decision, calling it a move from the border well into the heartland of illogic and absurdity. In Part 4, Justice Sotomayor argued that the majority's holding creates constitutional due process problems, forces unnecessary protective appeals, and creates administrative chaos that benefits no one. She even invoked Kafka, saying the court's requirement that Riley file his appeal 16 months before the order he wanted to challenge even existed was truly Kafkaesque. Justice Gorsuch apparently wasn't willing to go that far in his criticism, whether on one or all of these points. Now let's talk case implications. So what does Riley v. Bondi mean going forward? Well, the immediate impact is pretty clear. This decision creates some significant procedural headaches in immigration law. For people in expedited removal proceedings who want protection under the Convention Against Torture, they now have to file what are essentially protective appeals within 30 days of their initial removal order, often long before they even know if they'll win their CAT claim. Justice Sotomayor wasn't exaggerating when she called this chaos. It's telling that even the government supported Riley's position here, which suggests they recognize this creates administrative problems. The supposedly streamlined removal process now might get clogged with premature appeals that wouldn't have been necessary under the old approach. But Justice Thomas's concurrence adds another wrinkle that could make things even more complicated. He flagged a potential jurisdictional problem, basically questioned whether courts can even review these CAT decisions if someone doesn't also challenge their underlying removal order. That could create situations where people fall through the cracks entirely, either by filing too late under the majority's timing rules, or by not having the right to judicial review at all under Thomas's jurisdictional theory. How this all plays out will really depend on how lower courts handle these cases. Will they adopt the majority's suggested workarounds like holding early appeals until the CAT proceedings finish? The decision leaves a lot of practical questions unanswered, and it may take more litigation, or even congressional action, to sort out. Thanks for listening to today's episodes. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Talk to you soon.